Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields.
Afternoon everyone, and welcome to Business Legal Lifecycle TV. Today is Monday and it's the first Monday of a new month, so we're moving on to a new phase, which is phase 8 and 12 of the Business Legal Lifecycle. As always, I'm here, Craig Mason. I've also got with me Jeremy. Say hello to our listeners, Jeremy.
Hi everyone, hope you're having a great day.
Excellent. So as I said, we're moving on to a new phase for the month of July 2018, and it's regarding estate planning and retirement. Is there anything you wanted to add about the new phase?
No,
Jeremy?
we'll go through next week. We'll go through and do the education show. We've got an interview for this week, but we'll go through and explain why we're doing phase 8 and 12 together and give people a bit of an explanation about what to look for in estate planning. But I think we kick into our show today, 5 reasons to challenge a will. Do you want to kick it off with the first one?
Absolutely. And we'll have the slides on Wednesday or the following Wednesday with the Business Legal Lifecycle on there as well, so we'll see where it is. First one for Fast Fix Monday today is 5 reasons to challenge a will. So the first one is regarding testamentary capacity. So the law in most jurisdictions requires someone to have to be over the age of 18, an adult obviously, to do a will, and they have to have capacity to create the will. So if you're a minor under the age of 18, then you don't have legal capacity to create a will. But if you're over 18, you've got to basically understand what you're doing. You're able to give instructions. You understand your estate, who it is that you want to give it to, those sorts of things. So you've got to have the mental capacity or the testamentary capacity in order to make a will. So a lot of challenges come where someone doesn't have testamentary capacity, or someone believes they don't have testamentary capacity, and they challenge the will on the basis they didn't know what they were doing when they were signing the will. So that's the first reason for a will to be challenged. The second one, Jerry.
The second one, Craig, is fraud, forgery, and undue influence. So what we're talking about here is that if someone's been forced to sign a will, or you can prove that it was fraudulent or a forgery, then you can actually challenge that will and it may not be binding. So the term undue influence merely means that the person lacked the free will to bargain and write the actual will themselves because they've been manipulated by someone. This can be very tough to actually prove, but it's something that you need to be aware of if you're concerned that the will could be challenged. Craig, number 3.
Number 3 is where there's a later will or another will that basically trumps the one that is being administered. So you would challenge that will on the basis that you have a more recent will, for instance. And there's a lot of challenges on that basis. There's caveats lodged in the Supreme Court in Queensland and equivalent in other jurisdictions, basically saying that, hold on a second, I've got a different will that is after that will, and therefore revoke the previous will, and this is the will that should be used. So that happens a lot. So that's number number 4 challenge, Jeremy.
The number 4 challenge is sufficient and appropriate witnesses. So a will in different jurisdictions have different rules about who needs to witness a will and how that's to occur. So you've got to be very, very careful. Some states in America require 3 witnesses. Queensland in Australia requires 2 witnesses. And basically you need to be independent, so not be an heir in the will itself. So you've got to be really careful and make sure that you have the sufficient and appropriate witnesses. Later in this month, we'll talk a bit about the dangers in doing your own will. And this is one of the big ones that sufficient and appropriate witnesses haven't actually properly witnessed your will, which makes it harder to enforce. Craig, the 5th and final one.
Yeah, absolutely, is generally the will's actual provisions that are contained within it. So most jurisdictions have, the legislation about what has to be in a will in order to be a valid legal will. It's got to be that it was the testator that actually created the will.
Yep.
Includes at least one actual clause dealing with the property, and that it appoints a personal representative or an executor to be responsible for administering the will. So there's certain things that need to be in the will, and if they're not in there, then that can create a challenge. So it's pretty important that you make sure you've got at least something in your will, otherwise you're going to end up in court, unfortunately, or your estate's going to end up in court. So.
Yeah.
All right, so they're the 5 reasons that we've come up with today for the most common reasons, I guess, for challenging a will in most jurisdictions. So that's it for Fast Fix Monday. We'll be back again on Wednesday for interview episode. So hopefully you can join us then. But Jeremy, you got anything else to add about today's show?
No. Hope everyone has a great day, and we'll see you on Wednesday.
Excellent. Bye, everyone.
Bye.